Hi, my name's Gemma Clover and I'm an associate at Nichols Family Lawyers. Today we're talking about de facto relationships and friends with benefits and whether friends with benefits is a de facto relationship. So what is a de facto relationship? In Australia, the law recognises de facto relationships, which refer to the relationships between two individuals who are not married or related by blood, but who live or have lived together on a genuine domestic basis. So, when is it important to know if you're in a de facto relationship? For example, determining whether a friends with benefits relationship is in fact a de facto relationship becomes crucial when one party seeks to initiate asset division proceedings. So in considering whether a couple is in a de facto relationship, the court may give regard to any of the following factors, which are non-exhaustive. So the length of the relationship, the nature and extent of shared living arrangements, the degree of financial independence, the extent of mutual dedication to a shared life, and the reputation and public aspects of their relationship. In a recent case of Jones and Machete in 2022, the court considered whether a 16-year open relationship would be considered a de facto relationship. Although there was no dispute as to whether the relationship was romantic and intimate in nature, the court was unable to establish the existence of a de facto relationship on the following bases. The parties maintained separate residences. Despite the relationship's duration, it lacked exclusivity as the applicant was in another de facto relationship during this time. There was no shared property, and finally, the parties did not publicly present as a couple living together on a genuine domestic basis. But what if there were children involved? Does the existence of children automatically make the relationship a de facto relationship? It's important to know that the presence of children does not automatically establish the existence of a de facto relationship. Notably, in Swinbank and Stein, which was a case from 2022, the court had to determine whether a 14-year relationship, which resulted in 2 children, qualified as a de facto relationship under the Family Law Act 1975. So in this case, Mr. Swinbank argued that the relationship was de facto, while Ms. Stein maintained that their connection was, at best, a casual sexual relationship. The court found in favour of Ms. Stein, basing its decision on the following factors: the absence of a shared residence, no joint ownership of assets between the parties, the children were not planned, lack of financial interdependence, and insufficient evidence to suggest a commitment to a shared life together. Ultimately, the determination of whether a physical relationship qualifies as a de facto relationship will turn on each set of unique circumstances. For this reason, it is important to remain aware of the potential legal implications of entering into a friends with benefits arrangement in order to safeguard potentially conflicting financial interests. If you're unsure whether you're in a de facto relationship and whether your assets are at risk, feel free to book a conference with one of us at Nichols Family Lawyers via the link below.